Welcome to the Arbitration World podcast, in which we focus on significant developments and issues impacting international arbitration. We hope you enjoy this discussion. Please do get in touch with us if you have any questions about this week's episode or any areas you would like us to cover in a future podcast in this series.
Welcome to the KNL Gates podcast series, where we look at trends in international arbitration in different regions. In this podcast, we're interviewing Mr. Vivekananda Neelakantan, Registrar of the Singapore International Arbitration Centre, the SIAC. My name is Joan Lim-Casanova, a partner from the Singapore office, International Arbitration Group. This is the second part of a two-part series, whereby in the first, we talked about the key features of arbitration under the SIAC rules, and in the second, which is this, we will be talking about the trends in international arbitration in Singapore, Asia, and beyond.
This podcast is limited in scope as appropriate for a general audience and the applicable time constraints. The information in this podcast is not offered as legal advice, which should be obtained from properly licensed legal professionals on the basis of the specific facts of a given case. All speakers appear in their personal capacity, and any opinions or views offered are those of the relevant speaker alone and do not necessarily reflect the views of KNL Gates Straits Law, KNL Gates LLP, or any other entity or individual. Let's move on to the trends that you are seeing, Vivek. You mentioned earlier that in 2024, SIAC saw cases brought by parties from 72 different countries. Can you tell us a bit about the top 3 foreign users, and have they remained about the same, or are there any new entrants using SIAC?
The top users at SIAC, I think, as you perhaps anticipated, have generally remained consistent. China, India, and the US have, I think, over the past decade at least, contributed significantly in terms of the number of users that we have seen in our cases. That has also remained the case for 2024. But in 2024, we had a number of South Korean users in our cases, partly due to some related cases which involved a number of South Korean claimants. The other top foreign users for us have included parties from Australia, Indonesia, Japan, the UAE, and the UK. And that doesn't come as a surprise, particularly for the top 3, China, India, and the US. Those are, of course, the big economies in the world. China and India in particular are Asian economies that are fast growing. And it stands to reason that there are a number of cross-border contracts and consequently disputes that land up in Singapore and at SIAC. And similarly, with many of the countries and economies in ASEAN, most notably, I think, Indonesia, Vietnam, and Malaysia, we do tend to see a number of cases that come from these countries. I think of particular note is the UAE, which has seen some growth in recent years in terms of the number of cases. And as I think many of us will recognize, disputes tend to follow economic activity. And where there is more economic activity, there is greater potential for disputes and arbitration.
Yeah, certainly UAE is a hot spot for us at the moment. It's also interesting that you mentioned in 2024, you see more South Korean claimants. In our Singapore office, we've got quite a large number of Korean lawyers, including partners. Now let's move on to talk about digital security in international arbitration. Many law firms have their own digital vaults. Different law firms use different things. For example, some have SharePoint, iManage, Box, iBox, and they all have different names. And arbitrators find themselves often having to download different webs or software so as to be able to download the materials given to them by the law firms. And when they're unable to do so, sometimes they use Gmail accounts or they ask for USB sticks. Does SIAC render any assistance to arbitrators to ensure digital security and, confidentiality of information?
Yes, we do. And I mean, firstly, I'd say confidentiality, of course, is a key consideration. Our rules contain fairly robust provisions on confidentiality, and I think they are very much something that the users want from international arbitration. But going back to digital security and document management, we introduced the SIAC Gateway platform, which is our online e-filing and case management system in 2024. And Gateway essentially serves two functions. One, it provides for electronic filing of cases at SIAC and makes that rather seamless. You can essentially do so at any time by accessing the portal. You can input the relevant information, upload your documents, such as your notice of arbitration and arbitration agreement, and you can pay the filing fees online using a credit card or online wallet. But Gateway also acts as a document repository, much like what you said. And as we all know, I think international arbitration very much relies on and depends on submissions and documents that parties intend to rely on and form the case record. With Gateway, now parties can simply file and upload all of their submissions and documents and their evidence into the document repository. Parties have their own portals, they have their own secure access to the portal, and it allows tribunals to then access what is filed by the parties in a single portal, which makes access easy across the course of a case. We're all familiar with file sharing links, for instance, which expire in a month or so. And if you wish to come back to it towards the end of the case, it's often not available. And it can make the process a bit cumbersome. And I think Gateway was our answer to ensure that parties and tribunals have a somewhat seamless access to the case record, as also for the Secretariat to be able to access the case record. Because as you know, we review and scrutinize draft awards at the end of a case or at any point of time when a draft award is made by the tribunal, which allows us then to review the award with reference to the case record and the submissions that are made by the parties. We are, I think, also the first arbitral institution to obtain ISO certification in respect of our digital security. And in this, I think, day and age, it is a matter of great importance. The cybersecurity that we are able to offer as an organization is intended to assure our users that I think we take their data and its security and confidentiality very seriously.
Indeed. In the same vein, let's talk about the current hot topic, which is the use of AI. In K&L Gates, we invest heavily in AI to enhance productivity, and there are licenses granted to lawyers to use co-counsel to draft, for example, chronologies, whereby AI uses it. We check the accuracy of it. The judges in Singapore are also using AI to assist in their work. What is SIAC's take on the use of AI?
Yes, AI is here to stay. And I think all of us have used it in different ways in our personal lives, in our professional lives. You mentioned the Singapore judges. The Singapore courts recently, as you know, issued guidelines to say that AI is very much a part of the professional life of lawyers, and we recognize that you will use it, but emphasizing that your professional duties remain as lawyers under the relevant professional conduct regulations and so on. So it's very much here to stay. I think as an institution, we definitely want to be moving in the direction of using AI to improve our processes and assist us with various aspects of the institution, including, of course, case management. And there are a number of areas potentially where I think AI can play an important role, including, what we just spoke about, document management and, facilitating the organization of case files. It can potentially also help to develop best practices by analyzing case patterns and so on. It can be a valuable tool to act as a repository and a digital library, and to be able to analyze and track data from the cases, which ultimately there is a great hunger for in the community, both the arbitration community and the wider commercial community. I think it can also, of course, be very useful for case summaries and briefing memos, potentially also for selection of arbitrators to really identify situations and issues of conflict in a more robust manner. And it can also potentially be used for what I mentioned, which is the review of awards and scrutiny of awards. These are things that at the institution we are conscious of. We are piloting it in a very, very initial manner because I think there are naturally various issues that we have to be mindful of. So very simply put, I think there's always the risk of over-delegation. And that's something that all of us, I think, as legal professionals, we have to be mindful of. And even more so as an institution where I think the human touch has great value in how we run cases, we are mindful of that. So we are piloting some of these tools internally for us to understand better how AI can assist us with our work. One, of course, key consideration is confidentiality. And we want to be sure that confidentiality is something that can be assured in any kind of assistance that we obtain from any AI tools. And naturally, there are ethical issues concerning the kind of data on which the AI tools rely on. Given that international arbitration is generally a bit of a closed door, the data that the AI engines or tools rely on is limited, and it is limited to what you hold as an institution. We, of course, hold a massive amount of data on our own cases, but there is less data available out there in terms of what happens in international arbitration generally. So there are, I think, some issues to be mindful of, but notwithstanding that, I think there is tremendous benefit to considering the use of AI at this point, and it's something that I think we do already do in a very small way at this point in time. In the years to come, I think it will become a larger part of all of our professional lives, and I think that's definitely the way it will go.
Yeah, I don't mind arbitrators using AI, but what the clients or the users don't want is to have the arbitrators feed the materials or information into an open source AI to assist them into their work, because that compromises the confidentiality.
Yeah, some institutions or organizations have issued guidelines on the use of AI. The CIAC, for instance, just issued a set of guidelines which cover a number of areas on where you can or cannot use AI. It is also something that we would consider in due course on whether there is need to set out, some pointers on how you can or cannot use AI in the course of international arbitration.
Now let's move on to the challenges. When SIAC is administering an arbitration, what is the greatest challenge there?
I would say the biggest challenge is consistency of how you deliver your product. The number one product, of course, for any institution, at least and speaking for ourselves, I think we are quite clear on the product and the service we offer is case management and case administration. And if you go back to our primary expectations from users, you are looking for efficiency in the process, you are looking for high quality in case administration, and you are looking to ensure that everything that happens in the process of case management leads to a result that is enforceable and you can get to the final relief that you want. So as an arbitral institution, particularly one that deals with a large number of cases, I think it is our remit to ensure that we deliver on those aspects every single day of the week. And I think that is a challenge, of course, but it is a good challenge to have for us. And I think over the years, certainly SIAC's reputation on those fronts has been excellent. And that's something that we want to continue to maintain with the work that we do.
So we talked about the challenges when administering an arbitration. How about the challenges that SIAC is facing as an institution?
I would say there are probably 2 or maybe 3 challenges. One is, I guess, as an institution, you also perform the role of creating awareness on international arbitration. Of course, you do that in a multitude of ways. You organize conferences and meetings. We do a number of training events through the SIAC Academy in many different jurisdictions. I think there's always keenness and hunger for information on international arbitration practice, generally on understanding international arbitration. But the world is a big place. And I think we want to be able to spread the word as much as possible on international arbitration and best practices. But there is a lot to cover. And with, I think, the limited availability of the resources that you have as an institution, I think being able to do as much as possible is a challenge. And I think, nevertheless, we plod on and we do as much as we can on that front. And I think we would very much want to do more in respect of, I think, sharing information and training, so to speak. The second is somewhat related. I would say, again, from an institution's perspective, is really to have parties aware of the benefits of choosing an institution. And in many parts of the world, including the country that I come from, which is India, ad hoc arbitration is very common. And I think to have parties understand the benefit of institutional arbitration and switch to providing in their contracts that institutions will administer arbitrations is an ongoing challenge. And I think that's true for many different institutions. It's certainly true for us. I think to be able to create that awareness of the benefit of having an institution is, I would say, an ongoing challenge, because notwithstanding all of the discussion on international arbitration and institutions, you still have a number of cases that go to ad hoc arbitration. The third one, I suppose, is a function of, I think, the times we operate in, where there are a number of arbitral institutions that operate globally. Some are international institutions, some are local regional institutions. It is a crowded space, so to speak, in which you operate. The challenge really is not so much the competition as much as discerning for the user ultimately and the person who's drafting contracts, what is the best option for me? And it's horses for courses. It may not be that in every situation SIC is the best option or another institution is the best option. But I think that conversation and analysis around what is the best institutional option for me in a particular contractual situation is an analysis and a conversation that needs to happen perhaps more often. And it may at times, and this may be my own personal view, be crowded out by a lot of the conversations surrounding the many institutions that are out there advertising, their own services and their own product. So I think that is a challenge from the larger perspective, if I look at it as an arbitration lawyer, so to speak, and not necessarily one to which there is an easy answer, except to say greater awareness and more education and training is probably the key, and something that I think all of us play a role in.
Yeah, thank you so much, Vivek, for joining us. So if you want to use SIAC, if you go to SIAC's website, they've got the SIAC model clause that you can cut and paste into your contracts and to use them as the dispute resolution forum. So Vivek, thank you so much for taking the user feedback seriously, conducting consultation on the rules. We look forward to seeing more of SIAC in the international news.
Thank you so much, Joan. It's a pleasure to speak to you today.
Thank you for listening to this episode of Arbitration World Podcast. To listen to past episodes and receive notices for new episodes, subscribe by searching Hub Talks, that's HUB Talks, in your favorite podcast app. We hope you will join us next time for further discussions on hot topics and significant developments in international arbitration from around the globe.